This morning is Attorney Matthews and P.O. Kwasnick. Can you please identify yourselves for the record?
Good morning, Peter Matthews of the Public Defender's Office for Mr. Garceau.
And Dennis Kwasnick, Parole Officer to Department of Correction, Parole and Community Services.
All
Thank
right,
you.
there we go.
The purpose of this revocation hearing, this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by the preponderance of evidence. That is, the better or weightier evidence that must establish that. More probability than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation
Lisa, thank you.
of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded.
And streamed live and direct out of my basement. What up,
Testimony
Carson?
at today's hearing will be taken under oath. Inmate Garceau and Parole Officer Kwasnick, please raise your right hand. You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth.
Hey, what up,
So
Rosie?
help you God, or upon felony or perjury.
I do.
I do.
He does.
So I'm going to go over the procedure of the hearing. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. The state will have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all of the evidence presented, I will announce my findings.
Hey, what's up, Pisky Elf?
If I find that you violate one or more of the conditions of your parole, the state will have an opportunity to speak on your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No, I do not.
So we're going to go over your rights. You have the right to be represented by an attorney at this hearing, and counsel is present. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes, I did.
Do you have the right to review the evidence against you before this hearing? You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, I do.
So we're going to go over the charges. We will now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. P.O. Kwasnick, can you please read the violation details?
Charge 1 is reporting. You have demonstrated a repetitive pattern of non-compliance regarding reporting instructions. Between May 12th, 2025 and November 10th, 2025, you failed to report on at least 14 separate occasions. The dates you failed to report are 5/12/2025, 5/13/25, 6/2, 6/16, 6/17, 7/1, 9/15, 10/6, 10/27, 10/28, 10/29, 10/30, 10/31, and 11/10/2025. Charge 2 is curfew on November 16th, 2025 at 12:31 a.m. The Winchester Police Department conducted a motor vehicle stop involving Mr. Garceau. Although your GPS unit was malfunctioning at the time, the timestamp of the traffic stop indicates a violation of the curfew established in your GPS agreement of 9 p.m. until 6 a.m. Charge 3, program participation. On 10/31/2025, you admitted to using cocaine and were instructed to engage in a substance abuse treatment program for an evaluation. As of 11/12/2025, you failed to participate in the program as instructed. Obey all laws is charge number 4. There are 5 subsects or 5 sections of this. Section 1. On 4/25/2025, you traveled to Florida and received a citation for improper lane change. Number 2, on 7/6/2025, the Winstead Police Department investigated a larceny in which a victim paid you $1,700 to paint her residence. You failed to perform the work after approximately 1 month. When the victim demanded her money back, you stopped responding. Police spoke to you and you agreed to return the money by July 11th, 2025. However, as of July 14th, 2025, you did not refund the money, and a warrant was issued for 53A-125, larceny in the 4th degree as a result. Furthermore, on 11/17/2025, you failed to show up to court for the aforementioned offense, and a rearrest warrant was issued.
Connecticut.
Number 3, on 7/11/2025, I, Parole Officer Kwasnick, was notified by the Watertown Police Department that an arrest warrant for Mr. Garceau would be submitted after a woman paid him $400 for work that he never performed. You took the money and the victim was unable to contact you. Waterbury PD reported that they reached out to you, but you were elusive.
Who pays before they get the work done?
Watertown PD.
You're going to pay my house. I'm not going to pay you till after you're done.
6th degree, but would not be executed as your mother had paid the victim back, and the victim requested the charges be dropped. Your actions of taking $400 and not providing work violated 53A-125B, larceny in the 6th degree.
Like here,
Number
$400.
4, on 11/16/2025
Hell
at
no.
12:31 a.m. The Winchester Police Department conducted a motor vehicle stop of a vehicle that you were operating. You were issued an infraction for Connecticut General Statute 14-218A for speeding. During the investigation, officers determined that you were operating a motor vehicle with a suspended license and issued a verbal warning for operating a motor vehicle with a suspended license in violation of Connecticut General Statute 14-215. You're also required to have an ignition interlock device in any vehicle you operate. The vehicle you were operating was not your vehicle, which is equipped with an interlock device. When I asked Police Officer Green if the vehicle you were operating was equipped with an IID, he stated it was not. Your actions are in violation of Connecticut General
Hey, thank you, yo mama.
14-227K, operation of a motor vehicle without an ignition interlock device or tampering with an interlock device.
What up, Nicole?
Number 5, from 6/19/2025 until November 2025, you operated a motor vehicle hundreds of times with a suspended license in violation of Connecticut General Statute 14-215. Notification of arrest.
P.O. Kwasnick. So there's a no finding of probable cause, which was made on the charge number 5 of notification of arrest by hearing examiner Saunders. So we will not be considering this charge today, but you can continue on to charge 6.
One charge out of the
On
many?
both, subsections of notification of arrest?
Yes.
Okay.
He's definitely been keeping track of everything. He's been writing everything down on sticky notes.
Charge 6, drugs. On 10/31/2025, Mr. Garceau admitted to using cocaine from 10/27/25 until 10/30/2025 and signed a voluntary admission and misconduct. Charge 7, travel. On 4/25/2025, you traveled to the state of Florida without my knowledge or permission, evidenced by an infraction received there for improper lane change and your own admission. Number 2, on 6/16/2025, you went to the state of Massachusetts without my knowledge or permission. You did not have permission to leave the state. Charge 8, no driving. You only had my permission to drive the vehicle if it had an interlock device, if you had a valid driver's license, and had a legally registered and insured vehicle. Numerous times from 6/19/2025 until November 2025, you operated a motor vehicle with a suspended license in violation of Connecticut General Statute 14-215. Furthermore, on 11/16/2025 at 12:31 a.m., the Winchester Police Department conducted a motor vehicle stop of Mr. Garceau. He was issued an infraction for Connecticut General Statute 14-218A for speeding. During the investigation, officers observed that Mr. Garceau was operating a motor vehicle with a suspended license and issued him a verbal warning for operating a motor vehicle with a suspended license. for Connecticut General Statute 14-215. Mr. Garceau is also required to have an ignition interlock device in any vehicle he operates. The vehicle he was operating was not his vehicle, which is equipped with an interlock device.
Okay, so we are, the state has filed the following exhibits that have been marked for identification purposes. Can you please read the exhibits, P.O. Posnick?
Yep. Exhibit A, signed conditions of parole. Exhibit B, parole violation report. Exhibit C, notice of parole violation. Exhibit D, remand custody order. Exhibit E, copy of several Connecticut statutes, including 53A-125B, 14-227K, and 14-215. Exhibit F, emails and documents from the Connecticut DMV/collect. Exhibit G, copies of a citation from the state of Florida, case number 2025-121051-TRCI. Exhibit H, GPS agreement. Exhibit I, Intoxilock report. Exhibit J, Winchester case 25-10250, complaint ticket and description. Exhibit K, judicial branch printout of docket L18A-CR25-0191084-S. Exhibit L, emails from calls plus messages, paging contractor messages.
Awa.
Exhibit M, Winchester case number 25-5409. Exhibit N, prior misconducts. Exhibit O, voluntary drug admissions. Exhibit P, decision information summary. Exhibit Q, text messages between Mr. Garceau and P.O. Posnick.
This guy's like a one-man crime spree right here. Just
You
doesn't
also
know when
need
to
the
stop.
addendum.
Hey, Ash, thank you.
Addendum 1, on 3/3/26, Mr. Garceau appeared under docket L18W-CR25-0191084-S and pled guilty to 53A-125 larceny in the fourth degree and 53A-173 subsection A1 failure to appear in the second degree, and was sentenced to an unconditional discharge on both counts. All criminal cases have been adjudicated and the revocation hearing can proceed.
Thank you. Attorney Matthews, did you receive the notice of parole violation report, and other documents that I just marked for identification purposes?
I did.
And did you review this information?
Yes.
Okay. The defense has filed the following exhibits, which are marked as follows. Exhibit number 1, list of parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses. Attorney Matthews, do you request that any witnesses be allowed to testify at this hearing?
No, I have no witnesses for today.
At this time, the state will have the opportunity to call any witnesses, present evidence, speak to any evidence submitted. Do you have any witnesses or wish to testify?
I have no witnesses, and I believe parole violation and the evidence submitted speaks to itself.
Okay, thank you. It is now the defense opportunity to call any witnesses, present evidence, and to speak to any evidence submitted. Do you have any witnesses?
With all that larceny he was
I would
doing,
like to address the evidence.
no wonder he was able to afford all those trips to Florida.
So I'll start with charge 1 reporting. I did review the evidence that was submitted. I did look at Exhibit Q. I think Exhibit Q does demonstrate that Mr. Garceau did stay in contact with his parole officer.
Hey,
There was
Keza.
some difficulty he had in making these appointments. I do understand that, but for the most part, it seems like he contacted his parole officer. He stayed in touch with him and let him know what was going on with regard to his whereabouts. On charge 3, the program participation, the allegation is there was a missed evaluation on November 12th, 2025. Mr. Garceau, however, he did participate in extensive treatment both before and after this missed evaluation. He engaged in inpatient treatment at Rushford from July 9th until July 28th. He then completed additional inpatient treatment at the APP program from November 18th until he was remanded on December 18th when he was just about done with that program. He also engaged in ILP treatment through MCCA over the course of parole supervision. So while the charge here alleges one missed appointment, I don't think there's sufficient evidence that he failed to adequately participate in substance use treatment programs that were ordered by parole. Charge 4, obedience to the law. The first cited incident on April 25th pertains to a motor vehicle infraction. As that's not a criminal offense, I would argue there should be no finding with regard to that incident. The second incident pertains to the case where he pleaded guilty in court and he did receive an unconditional discharge on larceny for an FTA in the second degree. Mr. Garceau, he did plead guilty under the Alford Doctrine. He would like the board to know that the complaint was paid back in full. There's not a financial loss here.
His light turned off.
He did intend to complete this work. However, he was instructed to go inpatient on July 9th, and that did cause a lot of disruption with his ability to get this job done. He did want to contest these charges. However, given that he would not be able to receive a parole hearing until the charges were resolved, he did elect to accept a plea agreement for the unconditional discharge in order to resolve the matters. The third noted violation of obedience to law is a similar situation. However, this was not prosecuted in court. And I would argue here that there's insufficient evidence presented to find a violation based upon that incident. Here as well, the work could not be completed as scheduled because he needed to go inpatient on July 9th, which he did do. The money was returned to the client. In order to be convicted of larceny, the state needs to prove more than simply that money was paid and the work was not performed. They need to prove that Mr. Garceau acted with the intent to permanently deprive the complainant of money. Based upon the factual circumstances of this incident and the evidence that's been presented, I would argue the state cannot establish by a preponderance of evidence that he acted with the intent to permanently deprive the client of money. And I would argue there should be no finding with regard to this incident. The fourth alleged violation is that he was operating a motor vehicle without an interlock device. I would just note here that Mr. Garceau was not charged with that offense. He was not given a warning to that offense. The police report makes no mention of anything to do with an IID at all. And the final incident here under obedience to law is that the allegation is that he was operating a motor vehicle while his license was suspended. Again, this appears to be based upon intoxilizer records to show when his car was turned on. Again, I would just know he was never stopped by the police. He was never charged with that. And I think there needs to be more evidence than simply the fact that an intoxilizer is blown into to prove somebody's in violation of operating under suspension. There was no finding on charge 5. I'll skip that. And then charge 6, the drug use. Mr. Garceau did acknowledge that he had some struggles with substance abuse. He did engage in treatment. And after this incident, he did engage in inpatient treatment at the
Trish.
So I understand there were some struggles with drug use, but he was taking a lot of steps to address it. And he's planning on continuing to address that in the future. Charge 7, I would just ask, I'm going to ask Mr. Garceau a few questions here with regard to charge 7. Mr. Garceau, why were you in Massachusetts on June 16th, 2025?
Good question.
My uncle had unexpectedly passed away, and I went with family to the hospital while he was in passing. It was a sudden thing, and I didn't think to call parole at the time that it happened. It was just an instinctual thing, and I had went. But I told my parole officer that I had left the state and gone to Massachusetts for my uncle's death.
Thank you. And why did you travel to Florida on April 25th, 2025?
My son had passed away October 19th of 2024, right after I made parole for this situation. And I went down there to collect his ashes.
Thank you. And finally, did you have conversations with Officer Quadnick about your ability to drive a vehicle?
Yes, I did. When I first came home, my license was suspended for 23 years.
23 years?
They gave me my license back.
Big mistake.
With the IID in a vehicle for a year. I went and took my driving test. I obtained my license. I had IID put in my vehicle. And Mr. Kwasnick knew that I had my vehicle with everything legal. It was probably like the second week that I came home that I had all that situated and I was allowed to drive with the understanding that, I had my license and IID in the vehicle. I went to parole numerous times in my vehicle. which parked right outside of his window. He knew I was driving. He would come to my house. My truck is parked right there. So with the suspension, I paroled to my mom's house when I first came home from parole. I transferred my parole to my house. I was working on my relationship with my ex-wife. My mail was not going there, and I did not honestly know that my license was suspended until I got pulled over in November, which was a shock to me because I paid the fine for the improper lane change in Florida, and I didn't know that I had to send the receipt and confirmation of the fine or the ticket paid to the Connecticut DMV because I never received anything.
Wait,
All right.
what?
I
Thank you
thought
very
just
much.
be.
Thank you.
Come again? Can somebody translate that for me?
I like to hear
I don't
from
intend
different
what he
points.
was trying to convey
All
to
right.
us over here.
P.O. Quasic, would you like to make a closing statement before I make my findings?
Sounds like a bunch of horse manure,
yeah.
if you will.
In terms of the reporting and text messages, you can see, and I think the text messages are provide that although Mr. Garceau would update me on his location, he still wouldn't report. It would be right before he's supposed to report and give me excuses like his car was in an accident or he's right around the corner in Harwinton. I would sit at the police department for sometimes 6-7 hours waiting for this guy to report. It was just a pattern of him using drugs, not reporting, trying to gain them into compliance. The program participation, I mean, this was after extensive graduated sanctions that he had to go to Rushford, and missing MCCA after the relapse. I believe it was MCCA.
Hey, thank you, Linda.
That's why he had to go to the App Foundation. This was a graduated sanction because he just was not participating into the programs. The criminal offense, going to the July 9th inpatient, of the intent to defraud.
What I want to know is what he has on that
guilty
paper right
to
there. What's
the
on that
larceny.
paper?
With the other one, I understand I don't have the old warrant. It was signed, but the GA-18 decided not to prosecute it because the victim said, I don't want to prosecute anymore. It does not mean a crime did not occur. The IID for charge 4, I mean,
Doodles.
reinstated this. So despite his license being suspended since June 2025, those interlock reports indicate that he operated the motor vehicle hundreds of times while it was suspended. It was suspended because he went to Florida without my authorization or
The
knowledge,
next coca order.
received a motor vehicle infraction, which is violating the law. That's why he was issued an infraction, which resulted in his license being suspended because they were sending him notices, which he didn't pay. So the DMV suspended it. All that documentation is included for the DMV and the collect printouts showing that his license was indeed suspended. The Intoxilock reports show that he did start the vehicle. He admitted that he is the only one that drives this truck. Let's see. November 16th, Mr. Garceau was stopped driving that vehicle that was not equipped with his required interlock device.
Damn,
So
son,
under
where'd you
Connecticut
find
law,
this?
operating the vehicle without the required interlock device is a serious offense. It carries at least a mandatory period of mandatory minimum of a year. The reason Winstead PD did not arrest him for that citation, they didn't click on the collect terminal, the screen to show that it was required, that the IID was required. So consequently, the officer only submitted the speeding infraction.
Smoke
And a
weed
verbal
every
warning
day.
was issued for driving with a suspended license rather than the appropriate criminal charges. We had conversations with GA-18. The prosecutors were willing to prosecute the interlock in the license violations. However, because Mr. Garceau immediately pled guilty for that speeding infraction and mailed it in, the case was considered in motion, preventing the state from adding more serious charges to that of the specific incident of driving without an interlock device.
Hey, Tracy, thank you.
Drug use, I mean, the misconduct speak for themselves. The travel pass, I understand for family issues, this would have not been a problem. I would have submitted it. More than likely, he would have been approved. I can't see a reason he would not be approved to go down to get his son's ashes. However, his parole conditions are very clear. He's been violated in the past for going to different states when he's on parole, when he's supposed to be requesting these travel passes. This is not new. He knows he's on parole. He's supposed to request a travel pass. And it would have been granted, but he chose not to even request it and just go out of state. And then finally, the driving, yes, he was allowed to drive. He showed me the valid license, registration, and insurance. However, when DMV is mailing you letters saying it's suspended, and I spoke with DMV and they said the letters went out and so on and so forth, he was notified that the license is suspended. They're not notifying me because they don't know he's on parole. So ultimately, he did break the law. He was driving. He was allowed to drive by me, yes, while it was a valid license, registration, and insurance. But as soon as his license was suspended, I wouldn't have allowed it. And I told him he has to drive the IID, which he was doing in Winchester at midnight in a different car, circumventing basically the IID and driving a car that wasn't equipped with one. So my response to the concerns addressed by the defense.
Book him, Dano.
I can briefly respond to a few of those points.
Yes.
Yes.
So with regard to the program participation, I understand he struggled with drug use, but I just don't think the evidence is there to show that he wasn't participating. Going inpatient twice, doing ILP, doing at MCCA, doing outpatient after that, I think he has demonstrated a willingness to work with these programs and participate in the programs. There's one missed appointment. There may have been other issues he's had with these programs, but what we have in front of us and what the evidence is that he did do, I don't think there's preponderance of evidence that he did not participate in these programs. With regard to the charges, yes, I understand a finding can be made based upon the guilty pleas on the second one there. But the third one, which is a similar circumstance, I just don't think the evidence has been submitted to show that he acted with the intent to permanently deprive somebody of money. We don't have the warrant in front of us, and even if there was a warrant in front of us, the state would have to prove that. And based upon the factual circumstances here, I don't know if the factual circumstances were included in the warrant or not, because it's not here. I just don't think that they could establish that in this case. I just wanted to correct one thing about the 227K. The mandatory minimum for that is not a year unless it's a third offense. It's really a 1 year. It's a 30-day mandatory minimum for a first offense of operating without an interlock device. And
They haven't said how long he's been
additionally,
in prison for at this
nothing else
time,
to add on that issue. That's all I have to say. Thank you.
or not that I
Thank you.
heard,
Thank you.
not that I recall, if you will.
I will now take a moment to review this case and will notify you of my findings in a moment. I'm going to take a brief recess and then I will come back to when I make my findings.
A
Okay?
brief recess.
So I'm
Come
going to
on
go
now.
off the record and I'll be back. Thank you.
The hell? Just let us know what it is right now. You know whether you're gonna violate him or not. But he got enough. He got
Sir,
enough.
just to let you know, we are still connected to the live stream. So if you can just sit there quietly, anything you say would go out to the public.
Yes, ma'am.
Hey, what's up, doctor? How's it going? All right. For anybody that's just joining up right now, this is going to be a board of parole hearing from the state of Connecticut, if you will. I'm going to speed it up. This is from earlier on today. This is not being live streamed, except for me. I am live, but this stream is not. It's from earlier today, if you will. Give me a moment. I'm going to speed it up so we could go ahead and get on with the functions.
Infraction and does not meet the element. Okay, I'm going to make my findings.
All right.
On charge number 1, condition of reporting, in regards to the dates of 9/15/2025 and 10/31/2025, a no finding was made at the preliminary hearing by hearing examiner Saunders, and therefore we will not be considering them at the revocation proceedings today. The remainder of charge number 1, I find that you violate condition of reporting based on the evidence presented in State's Exhibits A, B, N, and Q. On charge number 2, I find that you violate condition of curfew based on the evidence presented in State's Exhibits A, B, H, and J. On charge number 3, I find you violated the condition of program participation based on the evidence provided in State's Exhibits A, B, N, and Q. On charge number 4, condition of obedience to the law in regards to parts 1, 3, and 5, a no finding was made at the preliminary hearing by hearing examiner Saunders, and therefore we will not be considering them at this revocation proceedings today. Regarding part 4 of charge number 4, a no finding is entered on Connecticut General Statute.
What up, MX?
13-218A, speeding as it is an infraction and does not meet the elements of this charge.
That's right, Jenna.
A no finding is also entered on Connecticut General Statute 14-227K, operation of a motor vehicle without an ignition interlocking device or tampering with an interlock device. As Exhibit F indicates that Mr. Grosseau did not have the right to operate a motor vehicle on 6/19/25 due to a suspended license. Therefore, the elements of this charge were not met by the state. For the remainder of charge number 4, I find that you violated the condition of obedience to the law based on your conviction for failure to appear second and larceny fourth on 3/3/26, for which you received an unconditional discharge. In addition, the evidence provided in support of the charge are State Exhibits A, B, F, J, K, and F. On charge number 5, conditions of notification of arrest, a no finding of probable cause was made for this charge by hearing examiner Saunders, and we will not be considering this charge today. On charge number 6, I find that you violated the conditions of drugs based on the evidence presented in State's Exhibits A, B, N, and Q. On charge number 7, I find that you violate condition of travel based on the evidence presented in State's Exhibits A, B, G, N, and Q.
What up,
And on
Melissa?
charge number 8, I find that you violate condition of no driving based on evidence presented in State's Exhibits A, B, F, and J. That concludes the fact-finding portion of this hearing. Before I make my recommendations, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend. Parole Officer Kwasnick, do you wish to make a statement regarding Mr. Grosseau's violation, background, history, and history at this time?
Yes. Despite receiving extensive graduated sanctions, Mr. Grosseau demonstrated a persistent disregard for the conditions of his supervision. According to the DIS, which I submitted for evidence, he has 24 prior convictions and also
24
previous community supervision failures. This would be the 21st community supervision failure.
21st?
He has been afforded every possible tool to maintain his liberty. Multiple referrals to drug treatment programs. He struggled with addiction while he was out. He did not report.
At this point, what didn't he do?
Permission, convicted of new crimes. So again, he chose to continue.
So he's been to prison 21 times.
Citizens operating motor vehicles illegally while not bypassing the safety devices. Reinstating his parole would be incompatible with the welfare of society. He has 3 months to go. The state thinks that the final 3-month period of incarceration is the minimum necessary sanction to ensure public safety. Again, I have serious concerns with the motor vehicle and legal violations. His specific disregard for those motor vehicle laws and specific parole safety restrictions represents a severe threat to community safety. He was bypassing safety devices, EIID, driving under suspension. And then finally, Mr. Grosseau is on parole for a violation of probation.
I can't wait for him to start reading those notes or that letter he got right there in his lap.
Let's see if the DIS says approached a driver on the side door while holding a folding knife and demanding money. He then, I believe, was violated when he was on TS for that. Went on probation. And what probation, the VOP warrant says, according to the DIS, is exactly why he's here, again, with parole. He has substance abuse evaluations. He didn't go to them, follow up with any treatment deemed appropriate in the standard conditions of probation. He didn't report when the parole officer or probation officer was telling him. He didn't tell the probation officer immediately if he was arrested. He didn't submit to medical or psychological examinations, urinalysis, alcohol, drug testing, and or counseling sessions. And also, it should be noted, the new arrest while he was on probation, again, was the same behavior he pled guilty to, which was taking money as a contractor for $600 of materials and never doing the work. Police were able to seize copies of the text messages between the victim and Mr. Garceau, which corroborated the victim's versions of events. So the office also observed and seized a copy of a successful transaction. So this was all on the disc. So basically the same criminal behavior that has landed his violation of parole is the same reasons that his probation was violated. So with that, I'm glad that Mr. Garceau is in tier 4, which I read in his, his exhibits. He has a bad substance abuse problem that he needs to address, but the state would not feel comfortable giving him the last 90 days back out in the community.
Thank you. Attorney Matthews, do you wish to make a statement regarding the violation background or history at this time?
Yes, thank you. So Mr. Garceau, he is 46 years old. He was born and raised with his family
46?
here in Connecticut. He does indicate he has a strong support system here in Connecticut.
What up,
with
Lonnie?
His mother, his sisters, his aunts, and his children. He has a good relationship with his family.
How
He
embarrassing.
is released. He is looking to be sponsored by his mother, who resides in Torrington. And he'd be seeking a halfway house in the Torrington area as a backup option if that sponsorship is not possible. He has supported himself. He is working, painting and remodeling. He's been doing that for some time now.
Painting and
When he
remodeling.
release, he is planning on joining the Painters Union.
Painters
I
Union.
understand what
up, G?
Officer Klosnick is saying with regard to these convictions that we received for larceny 4, but I do think there were some extenuating circumstances there. Even just reading the evidence here, he was supposed to pay his money back by July 14th, and he went impatient a few days before that. He has to go impatient. He doesn't have a whole lot of options. When parole tells him to go impatient, he has to go impatient. I do think there are some extenuating facts here with regard to what happened. And I would also note that these individuals were paid back all of that money that was taken for him to complete this work. He has indicated, as I indicated, he's looking to join the Painters Union. He's been in touch with them already, and he is confident he'll be able to have employment through the union when he is released.
I don't think so.
He has completed his GED while he's been incarcerated. In addition to painting, he's worked construction at several different companies in the past. He's working now during his remand as a dorm janitor. He's been doing that. I do think he's worked with parole. I disagree with the conclusion that he was not working with parole and not engaging in treatment. He was engaged in a lot of treatment, as I indicated.
In
He
his
went
dreams.
He did relapse. I understand that. He's apologetic about that. And he has struggled, but I do think he was making a lot of efforts to work with parole and engage in the treatment. He was inpatient
Right, Kyle?
at Rushford for 30 days. He was inpatient at the App Foundation at 30 days. I also think it's noteworthy that he was remanded December 18th. At the time he was remanded, he had been inpatient for the past 30 days at the App Foundation, doing very well by all accounts. He was just about done with that program. So there were some problems earlier, but at the time of his remand, I think he's demonstrated an ability and willingness to work with parole and engage with the treatment that he does need. When he's released, he's going to continue with this substance treatment. As he indicated, he's been involved in tier 4. He's doing well. He does know he needs to engage in substance use treatment going forward. He also wants to engage in some sort of grief counseling, which he thinks may assist him in maintaining his sobriety by addressing some of the triggers for his relapse that he's been dealing with since the death of his son. So he is on parole, and it looks like, I believe, until August. So it's a little more than 3 months left. He's been incarcerated now for some time, I think since before Christmas.
So like
I would
3
ask
months.
him to be released at the next available date. And
Going
I
on
think he
4.
could benefit from having these last few months of supervision and transition rather than just spending it incarcerated and then coming out with no sort of supervision whatsoever. I don't feel that his conduct on parole has demonstrated an inability to work with parole or benefit from further supervision. He knows he needs to address the license situation going forward. That was a surprise to him when he found out that suspension had taken place. He needs to get that addressed. But with regard to the IID, unless I misheard, but the findings, my understanding is there was a no finding on the operating without an IID. So I would ask that not be taken into consideration at this time. He does want to get back to his family. He wants to get back to work. He wants to address his substance abuse issues, which he understands is going to be a lifelong project. Mr. Garceau, is there anything I didn't address that you'd like to say at this time?
No, I think you pretty much summed everything up. Just that.
It's about time he
You know,
moved, turned on the light.
I didn't expect life to be so hard without my son. And I relapsed because of it many times. In regards to the license, I wouldn't have driven. I would have taken care of it. It was a simple ticket. And I could have taken care of that if I knew, if I had received mail about the situation. Like I said, it was a simple improper lane change ticket. There was no malice on my part. I didn't intentionally not respond to it or not take care of it, because that's my license. That's my livelihood. I didn't have my license in a long time, and it was an accomplishment to me to get it back. So being suspended, it was a shock to me when I found out that my license was suspended.
Is he gonna cry? We got a crier on our hands.
And with the larceny charge, I didn't agree with being charged with it, so I pled under the Alpha Doctrine, and at the end, I thought the charges were going to be dismissed, and I wasn't going to be charged with them, but I was misinformed by the public defender. When that happened, I was in the parole office with Kwasnick, and he told me that I need to go to rehab. At that time, I told Kwasnick that I have 2 jobs going, one in Watertown and one in Winsted, and that I, you know, if I could possibly get a week or 2 weeks to do them. So
all this running around is getting me hungry.
Giving me money already. He said, no, you got to go to treatment now. Take care of it when you get back. And this is where these charges stem from. The morning I got out of Rushford, I knew I had a warrant. As soon as I found out I had a warrant, I called my mother. My mother has access to my money. She went and took $2,000 out of the bank for me and went and repaid the ladies for me because I couldn't have no contact with them because I was in the program. This happened 2 days before I was released from the program. My tools were on the job. I had thousands of dollars in tools on the job. I didn't leave with intention to take these ladies' money. I had the money in the bank. I was doing, you know, despite my relapses, I was doing pretty good as far as the work.
Pretty good.
And, there was no intention on taking money. I put myself in a situation to be taken away from the job by relapsing, and Kwasnick had to do what he had to do, and I respect him for it. He's tried to help me numerous times.
Yeah.
And like I said, the death of my son it's been weighing hard on me.
Hey, I could imagine that has to be hard.
2 weeks after I got here, I broke the same week I got here to get into it. It wasn't a stipulation. It's something I need for myself.
Hey, Steph, thank you.
I've been dealing with addiction a long time in my life, and I'm tired. I'm tired of it.
Tired of being tired?
So the first time in my life, you know, I've come to jail and I've utilized what they have here. And it's
first
made a
time
big difference to me. You know, as far as being able to like express my feelings and to talk to somebody and to get out what's on my chest instead of holding it in until I ultimately relapse, because I don't want to feel feelings anymore. I know when I do get out, if I am granted parole back or I have to discharge, I know that I have to continue with recovery. I know that I have to attend AA or NA meetings, which I never really have unless I was told to. But I know today that's something that I desperately need in order to stay sober and to live a happy life. You know, my mother just had surgery, a 7.5-hour surgery, and she just came home from the rehab yesterday, you know, and she needs her son home because she has nobody else. You know, my kids need me home.
For what? You're gonna be hitting the pookie.
Daddy, when are you coming home? You know, by my 8-year-old son. And it hurts. Yeah, I have an addiction problem, but I'm doing my best. I feel for the first time in my life, working towards my recovery. And I want to continue that when I come home. And if I'm granted parole, I take any stipulations to reintegrate back into society, you know, whatever it may be, a bracelet, anything.
It don't sound like it from his prior actions.
A little bit of time with
Driving out of state
to get my
2 times. I'm sure there's more than that.
Society, and to show that
Driving
can-
without
I
an
can put my
interlock.
best foot forward and do what I need to do. And with that,
Hitting the pookie.
I think I'm all set.
Thank you, Mr. Garceau.
Thank you.
Thank you.
I mean, I feel
Any
bad for him
further
losing his kid,
comments,
but
P.O. Kwasnick or Attorney Matthews?
it's like take some responsibility of your life.
No, just the dates I have.
46 years
It
old.
was July 11th that he was given the opportunity to give that money back. And they're saying that he went into Rushford on July 14th, 3 days later. So, and the police officer, when I spoke to him, both of them said they gave him multiple opportunities to repay it. And then he's just stopped contacting him. But that was
I don't
the
think
only
that the,
clarification.
I think you went in July 9th, not the 14th.
I don't know. And it was July 9th. I don't have.
I could imagine losing a kid is difficult
Attorney
and
Matthews,
tough.
anything? Oh, are you all set? P.O. Kwasnick?
Yeah.
Anything else?
Nothing else to add.
But then at what point do you stop using that as an excuse to get high and break all these other rules?
Okay. For a halfway house, or
Don't drop the
what's your
soap.
mother's address? Sorry, where would you like to go? Or
The same address that I paroled to in Torrington, which is the 170 Scoville Street, Torrington, Connecticut.
you say
Bullshit.
that again? That street
Bullshit.
again?
I think it's listed in our
You
report.
bullshit,
If you look at
nephew.
the future plans for
Bullshit.
reinstatement housing section, it has the sponsor address, name, and phone number.
Okay. Thank you, Attorney Matthews. All right, and then halfway house. Where would you like to go with that? Is
I
it
mean, the
play?
water barrier, Torrington area, anywhere where it's close to my mother, because like I said, she just came home yesterday from rehab, from having a 7.5-hour back and neck surgery, and she's not able to do much for herself, and she's the only one, she lives by herself. So my help would, you know, she really needs help.
They probably gave her
And I would
an
love to be there for her.
in-house nurse being that age,
Okay.
especially since she doesn't have anybody.
So I
'Cause obviously he's not reliable.
Testimony, reviewed all the evidence provided. Based on that, I recommend that your parole be revoked with no new re-parole date. That is an approximate 7-month period of confinement as a sanction, and that will bring you to your end of your sentence, which your end of your sentence now is 7/23/26. In the event the board lessens my recommendation, my recommended sanction, the following conditions are recommended: mental health evaluation and treatment deemed as necessary, strict no driving, a halfway house. My findings and recommendations will be forwarded to the board on April 16th, 2026. You should receive the official written decision from the board within a week from that date. The board may lessen the recommended sanction, let my recommended sanction stand. This concludes the revocation hearing, and I am going off the record.
About
Just one more
time.
time, what was the board meeting date?
4/16.
I definitely wouldn't put him down as an emergency
That's it.
contact for any type of
You're all
emergency.
set, Mr. Grosso.
Thank you.
All right, good luck, Dave.
Thank you.
Vayas con Dios. Anyhow, hey guys, I'm gonna take a break, but if you guys want to continue watching, I am gonna leave the stream running on my YT account. You might be wondering what's YT. You know that little red logo with the white triangle. It also the same name, collect call from. If you type that up, you'll find the stream. I do have two streams going on. I have Maricopa that has a blank screen, and then I'll have this one here, which would be the Connecticut Board of Parole hearings. I gotta go ahead and stretch my legs. I've been on here for about 2.5 hours. I gotta go ahead and get my blood circulating on my legs and whatnot, because back in December I ended up having a blood clot, and then I am on blood thinners right now. So I want to stretch my legs, and I want to get something to eat and hang out a bit before my daughter gets out of school. We're gonna go see Super Mario Galaxy movie today. So she's been asking for the last few days.
Good morning.
Morning. You guys ready?
Yes, do you have,
I have house kids right now.
Hey, but I do appreciate you
Okay.
guys.
All ready?
thank you, you can send them in.
All right. And like I said, if you guys want to continue watching, jumping over to YT, collect call from. All right. I highly appreciate you. If you guys haven't done so, please do so. Hit that follow button. It's free 99. It doesn't cost you a thing. It's like breathing air. Hitting the follow, dropping a comment, and jumping on over to my other platform. All of that will definitely help me out. We're about to be hitting 30,000 followers on the American account. On the British account, we're about to hit 24,000. So, we're definitely growing. Damn, they got this for an orange. Oh, this one looks like he might be a little spicy, if you will. Oh, yes. He's definitely not playing with a full deck of cards. If you catch my drift, the elevator's not going all the way up.
How you doing?
He might be a few French fries short of a Happy Meal. I might end up sticking around for this one. Looks like he might get up and throw the chair, if you will. I don't know. What do you think? No, I'm just playing. I'm not going to stick around. I got to go. I got to
I'll be
go.
with you in a sec, okay?
But I do
Okay.
appreciate you guys, all right? Come on over to the other platform. All right, guys. For you guys that came on over to YT, I appreciate you guys. To YouTube. Let me see here.
I am Parole Officer Menard, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Jay Hotchkiss, inmate number 283-733. Today is April 7th, 2026. This hearing is being conducted via video at the BOP Central Office in Hartford Correctional Center. Can you please state your name and full name and DOC inmate number for the record?
Yes, Jay Hotchkiss, 283-733.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Attorney Dean
Yes, good morning. Hannah Dean on behalf of Mr. Hotchkiss.
and P.O. Richardson.
Hi, good morning, Officer Richardson, Hartford District Mental Health Unit.
Thank you. This is a preliminary hearing which has three purposes under Connecticut law. To determine if there's a probable cause to believe you committed an act that violated the conditions of your parole. B, to determine if the act is sufficiently serious to warrant the revocation of your parole. And C, to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is a probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Hotchkiss and Parole Officer Richardson, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, I do.
Yes, I do.
Thank you. The procedure for the hearing: first, I will read your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. The state will have an opportunity to address the issue of probable cause and the severity of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
All right, we're going to go over your rights. You have important rights at this hearing, which I will now review with you. You have the right to an attorney, and Attorney Dean is present here today. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes,
And you have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
yes,
Okay. Now we're going to go over the charges. We will now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. P.O. Richardson, can you read charge number 1?
Charge number 1, excuse me, under GPS. On 3/9/26, you were placed on GPS monitoring and signed a GPS monitoring agreement, agreeing to abide by the rules of the GPS monitoring device. On 3/10/26, you removed the GPS device off your ankle. This is a violation of your signed GPS monitoring agreement. Specifically, I will remain on GPS monitoring for a length of time determined by a parole officer and will not remove the GPS tracking device or strap from my ankle without prior permission from a parole officer. Charge number 2, residence. On 2/26/26, you were placed at the Stein Halfway House in Hartford. This was your only parole-approved address, and at no time did you have permission to stay at any other residence. On 3/10/26, you left the Stein Halfway House to receive emergency medical treatment at St. Francis Hospital. After leaving the hospital, you did not return to the Stein House. You were unsuccessfully discharged and removed from the bed count on 3/11/26. Charge number 3, absconder. On 3/10/26, you left the Stein Halfway House to receive emergency medical treatment at St. Francis Hospital. Halfway House staff conducted a spot check at the hospital and were informed that you were not there. At approximately 3:38 p.m., you removed the GPS monitoring device from your ankle in a deliberate attempt to evade parole supervision and effectively cutting off all communication with your parole officer. You did not return to the Stein Halfway House at all and were unsuccessfully discharged from their program on 3/11/26. Charge number 4, drugs. On 3/6/26, you used cocaine and oxycodone as evidenced by your signed voluntary admission and positive toxicology test. Charge number 5, halfway house placement. On 2/26/26, you were placed at the Stein Halfway House in Hartford and signed a halfway house agreement, agreeing to abide by the rules of the halfway house. On 3/6/26, you left the Stein Halfway House on a treatment pass to go to an appointment at the Village. You were to return to the halfway house at approximately 3:30 p.m., and you did not. It was confirmed that you did not attend your appointment at the Village. You did not return to the Stein House until 4:50 p.m. on 3/7/26. At no time did you have permission from either halfway house staff or your parole officer to go to any other location than the Village. You also had no prior permission from your parole officer to stay anywhere except for Stein House overnight. Upon arrival, you submitted a breathalyzer that rendered a .017 BAC, as well as providing a discharge paperwork that you had obtained emergency medical treatment that day for alcohol intoxication. This is a violation of your signed halfway house agreement. Specifically, I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff. I will return to the halfway house for my community pass at my scheduled return time. If I am unable to do so, I will call program staff to explain why I may expect it to be late to receive a new return time, and I will not consume or possess alcohol in the halfway house. On 3/10/26, you left the Stein Halfway House to receive emergency medical treatment at St. Francis Hospital. Halfway House staff conducted a spot check at the hospital and were informed that you were not there. You did not return to the Stein Halfway House at all and were unsuccessfully discharged from their program on 3/11/26.
Thank you. The state has filed the following exhibits pre-marked for identification purposes. P.O. Richardson, could you please read the exhibits?
Sure. Exhibit A, signed conditions of parole. Exhibit B, remand to actual custody. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, signed halfway house agreement. Exhibit F, incident reports. Exhibit G, toxicology lab report. Exhibit H, Hartford Healthcare after visit summaries. Exhibit I, voluntary admission form. Exhibit J, signed offender misconducts. Exhibit K, signed GPS monitoring agreement. Exhibit L, offender violation notice. Exhibit M, Allied Universal Event History and Maps. Exhibit N, Discharge Plan Report. Exhibit O, Board of Pardons and Parole Decision Information Summary. Exhibit P, Board of Pardons and Parole Revocation Summaries.
Thank you. I'm going to relabel Exhibit F into two parts with the incident report on 3/6/26 and the incident report on 3/10/26. I'm also going to relabel Exhibit H, Hartford Healthcare After Visit Summary on 3/7/26 and 3/20/26. Attorney Dean, did you receive the notice of parole violation report, and the other documents I just marked for identification purposes?
Yes, we have.
Right, and were you able to review this information?
Yes, I have. Thank you.
And no defense exhibits have been filed by the parolee or parolee's counsel. Attorney Dean, did you need to continue this hearing to obtain any evidence?
Not at this time.
And today we have no witnesses. Attorney Dean, did you request any witnesses to be allowed to testify at this hearing?
Not today. Thank you.
At this time, the state will have an opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations.
I don't have any additional comments to make in regards to the charges specifically themselves. However, the state would just like to note that this is Mr. Hotchkiss's third violation of discretionary parole within a 2-year time period. The first violation occurred after 4 months in the community. The second violation occurred after 6 weeks in the community. And this third violation occurred after only 12 days in the community. Mr. Hotchkiss was only in the community for 8 days when he left the halfway house for over a 24-hour period of time, where his whereabouts were unknown. We did try to work with him, giving him another chance, trying to put him on GPS, referring him to a relapse prevention program. However, unfortunately, he was never able to make that appointment because 4 days later, his GPS he cut off and was completely unaccountable in the community. I would also like to note for the record that Mr. Hotchkiss's non-compliant behavior is not just in the community. Since his return to custody, he has received 3 Class A disciplinary reports, 1 for contraband Class A, 1 for interfering with safety and security, and 1 for an attempted assault on a DOC employee. So 3 very serious DRs, which we would like to note on the record, in addition to the violation that we're here for today.
Thank you. It is now the defense's opportunity to respond, to make a short statement, calling witnesses and testify with respect to probable cause and the severity of the allegations.
Yes, thank you. I will just note this was an unfortunate situation. My client does, I think, self-admittedly suffer and struggle with addiction. And while in the community, he did unfortunately experience a relapse. However, going forward, he does feel very strongly that inpatient treatment at a higher level of care would be beneficial and a good support for him. He has previously, I believe, engaged in that type of treatment a few years ago and believes that that would be helpful going forward once he's released back on parole. I would also argue the allegations here are not serious enough to warrant revocation of my client's parole and his continued incarceration. As to the tickets, I will speak with my client concerning those. I unfortunately don't have copies of those at this time. However, I will just note in the narrative section where it references the situation at the hospital and the situation when he was returned to custody. I will just note that my understanding is at that time he was seen at the hospital for intoxication. So I don't think that he was in his right state of mind when that situation transpired. But those are my comments. Thank you very much.
P.O. Richardson, anything else you would like to add before I announce my findings?
No, not at this time. Thank you.
Attorney Dean, anything else that you'd like to?
Nothing further. Thank you.
Thank you. I'm going to take a few moments to go over all the evidence presented as well as the testimony that I heard, and then I will announce my findings. All right, I will now notify you of my findings on probable cause. I make a finding of probable cause on charge number 1, GPS, based on the evidence presented in State's Exhibits A, D, K, L, and M. I make a finding of probable cause on charge number 2, residence, based on the evidence presented in State's Exhibits A, D, N, and F. F incident report on 3/10/26. I make a finding of probable cause on a charge number 3, absconder, based on the evidence presented in State's Exhibits A, D, F, incident report 3/10/26, L, and M. I make a finding of probable cause on charge number 4, drugs, based on the evidence presented in State's Exhibits A, G, and I. I make a partial finding of probable cause on charge number 5, halfway house placement, based on the evidence presented in State's Exhibits A, D, E, F, and N. I make a no finding in regards to the consumption of alcohol due to the insufficient evidence. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. The records office at this facility, as well as your parole officer, will be notified. At the revocation hearing, myself or another hearing examiner will determine if you violate the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what sanctions should be imposed. That is all.
So Mr. Hotchkiss, I'll set up a call with you, as will my social worker, so that we can prepare prior to your second hearing, okay?
Okay, all right.
All right, I'll talk to
Thank
you
you.
soon. Thank you.
Yes,
Thank
thank you. I
you.
appreciate it.
Thank you.
All right.
You're all set, sir.
All set? Okay, thank you. Appreciate it.
So you have Perez refused to see you guys.
Okay, so
Yeah,
he's
he's
refusing to come?
Yeah, yep.
All right, well, we will see Addison, please.
Just to confirm, does Perez know that it's for a parole revocation preliminary hearing?
Should I sign off?
Hold on, P.O. Delpane, okay?
Okay.
Thank you. Mr. Addison, can you grab the CO?
Sir?
So does Perez, does he know this is a parole?
I did tell him it was parole, yeah.
Okay, and
did
he's
tell him.
refusing that?
That's correct.
Okay, thank you.
All right.
P.O. Dilpayne, we're gonna do Addison and then we'll address the Mr. Perez, okay?
All right,
Thank
I'll go
you.
back on mute. Thank you.
All right. Good morning. I'm Parole Officer Renard, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Jamar Addison, inmate number 392595. Today is April 7th, 2026. This hearing is being conducted via video at the BOPP Central Office in Hartford Correctional Center. Please state your full name and DOC inmate number for the record.
Jamar Addison, 392595.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Attorney Dean
Yes, Hannah Dean on behalf of Mr. Addison.
and P.O. Babbage. Can you please identify yourself?
Parole Officer Babbage.
Thank you. This is a preliminary hearing which has three purposes under Connecticut law. One, to determine if there's a probable cause to believe you committed an act that violated the conditions of your parole. B, to determine if the act is sufficiently serious enough to warrant the revocation of your parole. And C, to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Addison and P.O. Babbage, please raise your right hands. You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon felony of perjury?
I do.
I swear.
Thank you. The procedure for the hearing: first, I will read your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. The state will have an opportunity to address the issue of probable cause and the severity of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, sir.
We're going to go over your rights. You have the important rights at this hearing, which I will now review. You have the right to be represented by an attorney at this hearing, and Attorney Dean is present today. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes.
You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses, to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, sir.
All right, we're going to go over your charges. We will now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. P.O. Babbage, can you please read charge number 1?
Yes, charge number 1, halfway house placement. On 3/5/26, you signed out a Stein halfway house at 9 p.m. on a work pass with a return time of 9 a.m. on 3/6/26. At 9:15 a.m., you had not returned or contacted the halfway house. Program staff called you on your registered cell phone and you stated that you were 10 minutes away. You were given a new return time of 9:30 a.m. At 10:03 a.m., you had failed to return and all calls to your registered cell phone went straight to voicemail. You returned to Steinhaus at 5:15 p.m. and stated that you were having issues with your child's mother and had spent the day in, quote, Bum Park. You were unaccountable for approximately 7 hours and 45 minutes. This is a violation of your halfway house agreement, which states, I will only go to locations indicated on an approved community pass unless changes have been authorized by staff, and I will return to the halfway house from my community pass at my scheduled return time. If I am unable to do so, I will call program staff to explain why I'm expected to be late and to receive a new return time. On 3/6/26, you signed out of Steinhaus at 10 p.m. on a work pass with a return time of 9 a.m. on 3/7/26. By 11 a.m., you had not returned or contacted the halfway house. Staff were unable to reach you on your registered cell phone, and your employer confirmed that you had not been at work the night before. Your whereabouts in the community were unknown until you turned yourself in to P.O. Babbage at Hartford Parole at approximately 10 a.m. on 3/17/26, approximately 10 days and 12 hours. This is a violation of your halfway house agreement, which states, I will only go to locations indicated on approved community pass unless changes have been authorized by staff, and I will return to the halfway house from my community pass at my scheduled return time. If I am unable to do so, I will call program staff to explain why I'm expected to be late and to receive a new return time.
Thank you. The state has filed the following exhibits pre-marked for identification purposes. P.O. Babbage, can you please read the exhibits?
Yes. Exhibit A, parole conditions. Exhibit B, parole violation report. Exhibit C, notice of parole violation. Exhibit D, notice of parolee rights. Exhibit E, decision information summary. Exhibit F, remand to actual custody order. Exhibit G, halfway house agreement. Exhibit H, parole conditions. Exhibit I, halfway house agreement. Exhibit J, revocation hearing summary from 3/14/23. K, revocation hearing summary from 5/17/24. L, revocation hearing summary from 5/6/25. M, Steinhaus IR from 3/6/26. N, Steinhaus absconder IR from 3/7/26.
Thank you. Attorney Dean, did you receive the notice of parole violation report, and the other documents I just marked for identification purposes?
We have, we didn't receive Exhibit O, but I didn't hear it just listed, so we should be all set.
Okay, thank you. And were you able to review this information?
Yes, thank you.
No defense exhibits have been filed by the Parolees Council. Attorney Dean, do you need to continue this hearing to obtain or submit any evidence?
No, not at this time.
Today we have no witnesses. Attorney Dean, do you request that any witnesses be allowed to testify at this hearing?
Not for today's hearing, no.
Thank you. At this time, the state will have the opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations.
I just wanted to reiterate for the record that, so I was there that Friday night when Jamar returned. I had actually reached out to him and to his sister, who was able to convince him to come back. He came back. He had been at work that day. We talked about what had happened and his struggle with his child's mother. He asked for permission to go to work that night so that he didn't lose his job. And because he had been at work the night before, I allowed him to go out to work that Friday night. And then Saturday morning, he failed to return, and it was learned that he did not return, did not work. This is not his first time absconding. However, I'm only recommending a 6-month sanction this time because it is the first time that he did reach out to parole and turn himself in. And he did, in fact, report to Hartford Parole as directed and turned himself into custody to me.
Thank you. Sorry. Attorney Dean, let me find my place. It's now the defense opportunity to respond, to make a short statement, calling witnesses, and testify with respect to probable cause and the severity of the allegations.
Yes, thank you very much. And thank you, P.O. Babbage, for putting that on the record that he did turn himself in. I would argue the allegations are not serious enough to warrant revoking my client's parole. He was working well in the community. He was employed through On Track in East Hartford and reports doing his groups through CRT in Hartford. And previous to that, he was doing them through Wellmore in Waterbury. It appears that he didn't have any conduct issues while at the halfway house. And my understanding is he was good with his urinalysis. I believe those were consistently negative. And he was, I think, on the list to receive REACH housing through that program. I do believe that this situation was precipitated by my client, being unable to see his child, which I know was very difficult for him, and also being somewhat fearful of others in the community due to his prior charges. But I do, again, think it is relevant that he did do the right thing. He did turn himself in. And so I did just want to note that he, was willing to own up and take responsibility for this situation. Thank you.
Thank you. P.O. Babbage, do you have anything else that you would like to say before I announce my findings?
Yes, I would just like to say that I do think 10 days of unaccountability in the community does warrant further incarceration. I struggled with the recommendation and was advised to maybe go a little stronger, and I went with 6 months because he did turn himself in. However, this is, I believe, his 4th time, and he was well aware that Steinhaus was his only parole-approved residence. He absolutely was working. He was sober. He was on the referral list for scattered housing, but he chose to leave, and for 10 days, we don't know where he was and what he was doing, and I do think that's a very serious offense.
Thank you. Attorney Dean, do you have anything else to add?
Nothing further. Shamar, is there anything I didn't include that you want to say right now? I would just say, don't talk about the actual charges, but anything that you want to say that I left out regarding what you were doing in the community? You don't have to, it's up to you. Okay, thank you very much.
Thank you. I'm going to take a few moments to go over all the evidence presented as well as the testimony that I heard, and then I will announce my findings. Okay. I will now notify you of my findings on probable cause. I make a finding of probable cause on charge number 1, halfway house placement, based on the evidence presented in state's exhibits B, H, I, M, N. I find that the act is serious enough to warrant revocation. I have also determined that you should be detained while you wait for your revocation hearing. The records office at this facility, as well as your parole officer, will be notified. At the revocation hearing, myself or another hearing examiner will determine if you violated the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what sanction or sanctions should be imposed. This concludes the hearing.
Shamar, I'll reach out to you, as will my social worker, before we get our second hearing to discuss everything, okay?
All right.
Thank you. You're all set. Thank you, P.O. Babbage.
Thank you. Good luck, Jamar.
Regarding
That was the last
inmate-
one, correct?
Yep, I'm just gonna announce, I just gotta make a statement, and then I'll disconnect, okay?
Thank you.
Thank you. P.O. Delpane, I'm gonna make an announcement, and then you should be all set, okay?
Sounds good.
Mr. Paul Perez, inmate number 298262, refused to appear at a preliminary hearing. That is deemed that he has waived his right to preliminary hearing. Mr. Perez has a pending criminal matter and revocation process is continued until the criminal matter is resolved. It should be noted, Mr. Perez, special parole term ends on 5/26/26. Thank you. Thank you, P.O. Delpan.
All right. All set?
Yep,
All right. You have a good day.
you too. Thank you.
Perfect, thank you.
Good morning. I am Parole Officer Menard, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Rashad Bunkley, inmate number 356347. Today is Tuesday, April 7th, 2026. This hearing is being conducted via video at BOPP Central Office in Osborne Correctional Institution. Please state your full name and DOC inmate number for the records.
Rashad Bunkley, 356347.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning are Attorney Dean. Can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Bunkley.
Thank you. We're going to go over the purpose of the revocation hearing. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probability than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommended revocation, I will make a recommendation as to the appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Bunkley, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth. So help you God, or upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure of the hearing. First, I will read your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. The state is not present today at today's proceedings. However, you will have an opportunity to present any relevant testimony and relevant documents. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, sir.
Okay, so we're going to go over your rights, the rights of the parolee. You have the right to be represented by an attorney. At this hearing, Attorney Dean is present here today. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes.
You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Okay. So we're going to go over the charges. We will now review the charges that the state your parole officer is bringing against you and the information underlying each charge. On charge number 1, condition of obedience to the law, the charging officer reported on Friday, November 21st, 2025 at approximately 12:24 a.m. Hartford Police was dispatched on a report of a domestic dispute. Upon Hartford Police Department's arrival, they met with the complainant, Jane Doe, known to this parole officer in the Hartford Police Department as Diane Foster, who used to be Diane Porter, 7/14/1984. Diane stated she texted you and asked if you could stop by the house for a few minutes to talk with her. Diane texted you on 11/20/2025 at 11:30 p.m. On 11/20/2025 at 11:56 p.m., you texted Diane stating you were outside and to open the door. Diane explained to you that you needed to stay here for the night and watch the kids due to having to leave early for work. The kids due to her having to leave early for work. You became upset, refusing to watch the kids. Diane stated you yelled at her, telling her she can't tell you what to do anymore and you are not going to watch the kids. Diane stated as she was about to stand up, you slapped her with an open hand to the left side of the face. You then left her residence, running downstairs and out to your vehicle. Diane refused medical attention, and the Hartford Police Department did not observe any marks, scratches, or swelling to her face. However, Diane did complain of minor pain. Should be noted, you and Diane have had domestic violence issues in the past. Subsequently, based on the above facts, circumstances, and statements, probable cause exists and a warrant to be issued for the following violations. Connecticut General Statute, Disorderly Conduct, 53A-182, and Connecticut General Statute, Assault. Connecticut General Statute, Assault in the Third Degree, 53A-61 under docket number H14H-CR25-0775024-S. You have a bond amount of $500 and a next court date of 1/27/26 at 10 a.m. at Hartford GA 14. You are currently incarcerated at Hartford Correctional Center and held on remand to actual custody or authorized by a parole supervisor. I'm going to identify the exhibits and filings. The state has filed the following exhibits that may have been marked for identification purposes. Exhibit A, signed special parole conditions. Exhibit B, remand to actual custody. Exhibit C, parole violation notice and parolee rights. Exhibit D, parolee violation report. Exhibit E, BOPP decision information summary. Exhibit F, BOPP revocation summary. Exhibit G, arrest warrant, case number 25-027315 from Hartford Police Department. Exhibit H, CT judicial pending case details. In addition, the state's filed an addendum to the parole violation report that states Mr. Bunkley Rashad was charged with Connecticut General Statute 53A-182, disorderly conduct, and Connecticut General Statute assault third degree physical injury 53A-61, subsections A1 for an offense that occurred on 11/21/25. Mr. Bunkley was seen in court at Hartford GA 14 on 3/10/26 regarding docket number H14H-CR 25-077-5024-S. Mr. Bunkley received an unconditional discharge under this docket. Connecticut General Statute disorderly conduct 53A-182, Nolade 3/10/26, Connecticut General Statute assault third degree physical injury 53A-61, subsection A1, guilty 3/10/26. Mr. Bunkley, according to judicial case lookup, has no pending fees or fines. BOPP may proceed with revocation hearing at this time. Mr. Bunkley's EOS date is 11/15/2030 and is on special parole supervision. Did you receive the notice of parole violation report, and the other documents I just marked for identification purposes, Attorney Dean?
Yes, we have.
The defense has filed the following exhibits, which are marked as follows. Exhibit 1, Hartford Superior Court transcript dated 3/10/26, 11 pages. Exhibit 2, list of parole accomplishments and future plans for parole reinstatement. Exhibit 3, support letter from Diane Porter, and Exhibit 4, Laz letter. Today we have no witnesses. Attorney Dean, did you request that any witnesses be allowed to testify at this hearing?
No, thank you.
It is now the defense opportunity to call any witnesses, present evidence, and speak to any evidence submitted.
Yes, as to charge 1, I would just note the addendum is accurate. Disposition was just the one count of assault in the third degree for which my client received an unconditional discharge, no time to serve, no additional supervision. Other charges were all nollied. I would just like to note that while we understand this conviction was entered and my client accepted this plea, it is worth, I think, noting that the complainant on record in our Exhibit 1, that transcript, indicated that my client never physically assaulted her. And the same is also indicated in the letter of support that we had submitted at Exhibit 3. Furthermore, I would just note Exhibit G, which is the warrant in this case. In paragraph 8, the officer indicates he did not observe any physical injuries to the complainant. But those are my comments concerning the charges. I would, at the appropriate time, like to talk about my client's background and history. Thank you.
Thank you. Excuse me. And would you like to make any comments, make a closing statement before I announce my findings?
No, thank you very much.
All right, I will notify you of my findings. On charge number 1, I find that you violate conditions of obedience to the law based on your conviction of assault third degree physical injury on 3/10 when you received the sentence of unconditional discharge. In addition, I also make a finding in regards to disorderly conduct offense. Disorderly conduct offense, although it was not laid in court, I find that the behavior meets the preponderance standard based on the evidence presented by the state's exhibits A, D, and G. This concludes the fact-finding portion of this hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend. Attorney Dean, do you wish to make a statement regarding your client's violation, background, or history at this time?
Yes, please. Thank you. My client, Mr. Bunkley, is 35 years old, born and raised in Hartford. He does have a strong support system in the community, including his grandmother, his brother, and his 3 sisters. Previously, while incarcerated, my client did sadly lose both of his parents. His grandmother does require a lot of help in the community, and he was helping take care of her. He also has a 3-year-old son who he actively helps to care for. Most recently, upon release to special parole in July of 2024, my client successfully completed Steinhaus. He then was self-sponsored at an apartment through the Chrysalis program in Hartford, and then he was sponsored by his aunt also in Hartford. He reports obtaining various certifications, including OSHA and flagging from the Best Chance program out of Hartford. Most recently, he was working full-time as a valet at St. Francis through the LAC parking company for approximately 10 months. He was prior to that full-time at WB Mason warehouse in East Windsor. He does have extensive work experience in warehouses, including Trader Joe's, FHI, and also UPS. Most recently, he did successfully complete the Explore program in 2024. He does suffer with epilepsy, which he is able to manage through medication. My understanding is that he successfully completed his GPS monitoring while in the community. Upon reinstatement of his parole, he would like to be sponsored by his aunt, who he previously was sponsored by at the address in Hartford. Should he be placed in a halfway house, he would like the Hartford jurisdiction. He has, lived the majority of his life there and does have a strong support system in that area. He hopes to enroll in a cosmetology program for barbering, and also is hoping to go and do the tractor trailer training program to get his CDLA. He does have an opportunity to work doing flagging for a company out of New Haven. I believe he had secured that position prior to his remand, but he is hoping to return there. He's very open to any sort of treatment recommended, and he's most, I think, of all excited to reunite with his son, which is, I think, the most important thing to him. I am asking that you consider a sanction not to exceed 4 months for my client. He has been out for over a year and had been doing pretty well while in supervision. I don't believe has had any DRs since returning to incarceration. I also believe that he did turn himself in on the warrant for this case and did do the right thing there. Furthermore, we are requesting that I know oftentimes anytime there's a DV arrest, there's typically a request for a no contact order. We are asking that not be put in place with the individual with the initials DP. I think the evidence submitted shows that this was not a physical altercation and that both parties wish to have continued communication, especially for the sake of their child. And Mr. Bunkley, is there anything I didn't include that you would like to say at this point?
No, you pretty much said everything.
Thank you.
Anything else?
That's it. Thank you.
I've listened to testimony and reviewed all the evidence provided. A couple of notes before I announce my recommendations are, you have one previous violation while under this term of supervision, which was absconding and criminal. Additionally, you have a history of domestic violence. I did take into consideration that you were on supervision in the community for approximately 1 year and 6 months prior to this violation and no noted misconducts. Based on that, I recommend that your parole be revoked and that you serve an approximate 5-month period of confinement as a sanction with a re-parole date of May 29th, 2026. I recommend the following conditions: general no contact with DP without PO's permission, behavioral management for domestic violence. Although the parole violation report indicates this program was completed, the new violation behavior is family violence related, and therefore I will recommend this condition to be imposed. I also recommend halfway house placement. And your aunt's address is in the exhibit?
Yes.
Yes, okay. That's it. My findings and recommendations will be forwarded to the board on April 16th, 2026. You should receive the official written decision from the board within a week from that date. The board may lessen the recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I've recommended, then a supplemental hearing will be held. Before the hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed my recommendation. During the supplemental hearing, you will have an opportunity to respond to those specific reasons while in front of the panel of the board. This concludes the revocation hearing. I am now going off the record.
So Mr. Bunkley, I'll reach out to you, or if you can get a call into my office on the 16th, we can let you know what the parole board decides. As the hearing examiner stated, they could do one of three things. They can accept the recommendation he made. They could give you potentially less time, or they could give you more time. But if they did ask for more time, we would get another hearing, okay?
All right.
So if you want to just follow up with us on the 16th, we can let you know what they decided when they deliberate.
All right. Thank you.
Great. Thank you very much.
All right.
You're all set, sir.
All right. Thank you.